Chapter 11, Working with Direct Participation Programs. In this chapter, understanding the specifics of DPPs, distinguishing a limited partner from a general partner, getting a handle on the paperwork and taxes involved, looking at the different types of DPPs. Direct participation programs, DPPs, can raise money to invest in real estate, oil and gas, equipment leasing, and so on. More commonly known as limited partnerships, these businesses are somewhat similar to corporations, stockholder-owned companies. However, limited partnerships have some specific tax advantages and disadvantages that a lot of other investments don't have. According to tax laws, limited partnerships are not taxed directly. The income or losses are passed directly through to the investors. DPPs were once known as tax shelters because of the tax benefits to investors. However, tax law changes have taken away a lot of these advantages. As a result, DPPs have somewhat fallen out of the favor for investors, though not entirely for Series 7 designers. In this chapter, we explain the differences between limited and general partners, as well as the types of partnerships, their particular risk, and potential rewards. The info here can help you examine the risk and rewards and determine the suitability of DPPs for investors. I also explain two inevitable facts of life as they apply to partnerships: the filing of paperwork and the payment of taxes. As with just about every chapter, you'll receive some overlap between the information covered on the Securities Industry Essentials exam and the Series 7. Searching for identity. What DPPs are and aren't. Just as stockholders are owners of a corporation, limited and general partners are owners of a direct participation program, DPP. The key difference for people investing in DPP is that they're required to tie up their investment dollars for a long period of time, even though they receive tax advantages for do so. Most DPPs are set up for real estate projects, oil and gas projects, or equipment leasing. The IRS determines whether an enterprise is a corporation or a limited partnership. For a limited partnership to actually be considered in tax as a limited partnership, it has to avoid at least two of the following corporate characteristics, usually the last two. Having a centralized management. Corporations have management in one place. The challenges of managing a limited partnership from several locations make this corporate trait quite difficult for partnership to avoid. Providing limited liability. Corporate shareholders have limited liability. Well, so do limited partners. The liability of a corporate shareholder is limited to the amount invested, and the liability of limited partners is limited to the amount invested plus a portion of any recourse loans taken out by the partnership, if any. Providing limited liability is pretty much unavoidable. Having perpetual, never-ending life. Like corporations, which hope to last forever. Limited partnerships are set up for a definite period of time. Limited partnerships are dissolved at a predetermined time, for example, when its goals are met or after a set number of years. Having free transferability of partnership interests. DPPs are difficult to get in and out of, unlike shares of stock, which can be freely bought and sold by anyone. Limited partners not only have to pass the security of a registered rep, pass the scrutiny of a registered rep, but they also require approval of the general partner. DPP investors, limited partners, must show that they have enough money to invest initially, plus have liquidity in other investments in the event that the partnership needs a loan. For Series 7 exam purposes, you need to remember that the easiest corporate characteristics for a partnership to avoid are perpetual life, continuity of life, and having free transferability of shares. The most difficult to avoid are providing limited liability and having a centralized management. DPP characteristics: general and limited partners. By law, limited partnerships require at least one limited partner and one general partner. Limited partners are the investors and general partners are the managers. When you're looking at general and limited partners, you want to focus on who can and can't do what. And general partners are responsible for the day-to-day decision-making, overseeing operations, deciding when to buy or sell, choosing what to invest in, and so on for the partnership. Limited partners, the investors, provide the bulk of money for the partnership, but unlike general partners, can't make any of the partnership's investment decisions. Here's a table comparing general and limited partners. Decision making. General partners are legally bound to make decisions in the best interest of the partnership, make all the partnership's day-to-day decisions. Limited partners have voting rights but can't make decisions for the partnership. Tasks. General partners buy and sell property for the partnership, manage the partnership's assets. Limited partners provide capital, vote, can keep general partners in check by receiving books, reviewing books. Liability and litigation. General partners have unlimited liability, can be sued and held personally liable for all partnership debts and losses. Limited partners have limited liability, limited to the amount of invested and a proportionate share of any recourse loans taken by the partnership, and can inspect all the partnership books, can sue the general partnership, or can sue to dissolve the partnership. Financial involvement. General partners maintain the financial interest in the partnership. Limited partners provide money contributed to the partnership. Recourse debt of the partnership and non-recourse debt for the real estate DPPs. Financial rewards. General partners receive compensation for managing the partnership. Limited partners receive their proportion of profits and losses. Conflicts of interest. General partners can't borrow money from the partnership, can't compete against the partnership. For example, they can't manage two buildings for two different partnerships in close proximity to each other. Limited partners have no conflicts of interest, can invest and compete in partnerships. pushing through partnership paperwork. For the Series 7, you need to know about certain paperwork that's specific to limited partnerships. In the following sections, I discuss 3 required documents necessary for limited partnership to exist. Partnership agreement. The partnership agreement is a document that includes the rights and responsibilities of the limited and general partners. Included in the agreement are basics that you would probably guess, such as the name of the partnership, the location, the name of the general partners, and so on. In addition, the partnership agreement addresses the general partner's rights to change of management fee for making decisions for the partnership, charge of management fee for making decisions on the partnership, enter the partnership into contracts, decide whether cash distributions will be made to the limited partners, and accept or decline limited partners. Certificate of Limited Partnership. Certificate of Limited Partnership is a legal agreement between the general and limited partners, which is filed with the SEC for public offerings and Secretary of State in the home of the partnership. The Certificate of Limited Partnership includes basic information such as the name of the partnership and its primary place of business, the names and addresses of the limited and general partners, and the following items: the objectives, goals of the partnership, and how long the partnership is expected to last, the amount contributed by each partner, plus future expected investments, how the profits are distributed, the roles of the participants, how the partnership can be dissolved, whether a limited partner can sell or assign his interest in the partnership. If any significant changes are made to the partnership, such as adding new limited partners, the certificate of limited partnership must be amended accordingly. Subscription agreement. The subscription agreement is an application form that potential limited partners have to complete. The general partner uses this agreement to determine whether an investor is suitable to become a limited partner. The general partner has to sign the subscription agreement to officially accept an investor into the DPP. One of your jobs as a registered rep is to pre-screen the potential limited partner to make sure that the partnership is a good fit for the individual. Consider the following questions. Does the investor have enough money to invest? Does the investor have enough cash or liquidity in other investments in case the partnership needs more money? Are they okay with tying up his money for a long period of time? Can he manage the risk involving the risk of losing his entire investment? Also, you need to review the agreement to ensure, to the best of your ability, that the information the investor provides is complete and accurate. Besides the investor's payment, the subscription agreement has to include items such as the investor's net worth and the annual income, a statement explaining the risk of investing in the partnership, and power of attorney that allows the general partner to make partnership investment decisions for the limited partner. The following question tests your ability to answer questions about DPP paperwork. All the following statements are true regarding the subscription agreement except A. A limited partner must sign the agreement to officially accept a limited partner. B. A registered rep must first examine the subscription agreement to make sure that the investor has provided accurate information. C. After the general partner has signed the subscription agreement, it gives the limited partner power of attorney to conduct business on behalf of the partnership. D. The subscription agreement is usually sent to the general partner with some form of payment. The answer is choice C. The test designers want you to know, or want to know, you understand what this document is and that you have a grasp of who does what. The subscription agreement is a form that the potential limited partner fills out. Then the registered rep reviews the document before sending it with the investor's payment to the general owner, who signs to accept the terms. Choice B shows where the registered rep comes in. Here, you assume that the investor is the potential limited partner, so choice B checks out. Because this is a accept question, the correct answer is choice C. The subscription agreement gives the general partner, not the limited partner, power of attorney to make decisions for the partnership. If you remember that limited partners don't really do much in the way of decision making, you can spot the false answer right away. Types of DPP offerings. As with many other securities, DPPs can be sold privately through private placements or through public offerings. It's up to the syndicator, the underwriter, to help determine which type of offering makes the most sense. Private placements. If a DPP is to be sold privately, the indicator helps to fund several accredited investors who will become limited partners to distribute large sums of money. These accredited investors are persons who can afford to take the financial risk and typically have a lot of investment experiences. A private placement of DPPs is made through an offering memorandum, private placement memorandum. Private placements of DPPs are exempt from SEC registration under Regulation D of the Securities Act of 1933. Public offerings. Unless the transaction is exempt, as in private placements, all non-exempt security transactions must be registered with the SEC. Public offerings of DPPs are no exception. So in a public offering, not only do investors need to be pre-screened, but they also must receive a prospectus. When there's a public offering of a DPP, there will be a lot more investors, and the initial capital distribution will generally be much smaller than in a private placement. In some cases, investors may become a limited partner with an initial contribution as low as $1,000. Passive income and losses. Looking at taxes on partnerships. DPPs used to be called tax shelters because DPPs flow through or pass through not only income but also losses to investors. Corporations only flow through income. Prior to 1986, investors could write off these losses against income from other investments. Then the IRS stepped in, because it felt that this write-off was too much of an advantage for investors or the IRS wasn't making enough money, and decided to give the DPPs their own tax category. Now, because investors are not actively involved in generating the income, taxes on DPPs are classified as passive income and passive losses. So basically, DPPs are like corporations that have a tax pass-through exemption from the IRS. However, unlike corporations that are taxed on the corporate level prior to distributing dividends to investors, DPPs pass through untaxed income to investors. The key thing to remember for the Series 7 purposes is that investors can write off passive losses only against passive income from other DPP investments. Evaluating direct participation programs. Direct participation programs can be offered publicly or privately. Public offerings of DPPs must be registered with the Securities and Exchange Commission, whereas private offerings to mostly wealthy investors are not. Typically, publicly offered DPPs have a lower unit buy-in cost than that of privately offered DPPs. Certainly, direct participation programs do provide some advantages, but they also have additional risks that investors can't face with other types of investments, such as having to loan additional money to the partnership if needed. Therefore, when evaluating whether an investment of a DPP may be right for one of your clients, not only do you need to determine whether investing in a partnership is wise for the client, but you need to also consider the following items: the economic soundness of the program, the expertise of the general partner, the basic objectives of the program, the startup costs involved, and the leverage of other revenue considerations. Types of partnerships. Certainly, partnerships can be formed to run any sort of business that you can imagine, including business development companies, small cap, and debt and equity, etc. However, the Series 7 exam focuses on the big three: real estate, equipment leasing, and oil and gas. You need to be able to identify the risk and potential rewards for each of the following types of partnerships. Because of the risk associated with some of the different types of DPPs, investors should have the ability to tie up their money for a long period of time and be able to recover from a loss of all the money invested in case the partnership never becomes profitable. Real estate partnership info. Real estate partnerships include programs that invest in raw land, new construction, existing properties, or government-assisted housing. You need to know the difference among the types of programs along with their risk and potential rewards. Here are the three types of real estate DPPs from safest to riskiest. Public housing, government-assisted housing programs. This type of real estate DPP develops low-income and retirement housing. The focus of this type of DPP is to earn consistent income and receive tax credits. The U.S. government, through U.S. government subsidies via the Department of Housing and Urban Development, HUD, makes up any deficient rent payments. Appreciation appreciation potential is low and maintenance costs can be high, but the DPP does benefit from a little government security. Public housing DPPs are backed by the U.S. government and therefore considered the safest real estate DPP. One of the major benefits of public housing DPP is that they qualify for tax credits. Low income housing tax credits, or LIHTC. These tax credits or tax incentives are built into the IRS code to encourage developers to create affordable housing. The biggest risk for public housing DPPs is their lack of appreciation potential and the risk of having to foreclose on non-payers. Existing properties. This type of DPP purchases existing commercial properties and apartments, and the intent is to generate a regular stream of rental income. Because the properties already exist, this DPP generates immediate cash flow. The risk with this type of DPP is that the maintenance or repair expenses will eat into the profit, or that tenants won't renew their leases. The properties already exist and are producing income, so the risk for this type of DPP is relatively low. New construction. This type of DPP purchases property for the purpose of rebuilding or just building. After completing the construction, the partnership's goal is to sell property and structure at a profit after all expenses. Building costs may be more than expected, and the partnership doesn't receive income until the property is sold. But the DPP can benefit from appreciation on both the land and the structure. Although the investment is speculative due to potential increases in building costs, economic downturns, changes in tax laws, competing projects, and so on, is not as risky as raw land DPP. Raw land. This type of DPP invests in undeveloped land and anticipation of long-term capital appreciation. Raw land DPPs don't build on or rent out the property. The partnership hopes the property purchase will receive or appreciate in value so that the DPP can sell the property for more than the purchase price plus all expenses. Until that hopefully happens, investors have the cost of principal and interest of borrowed money plus carrying cost taxes. In the event that the land held by the DPP isn't sold in a reasonable amount of time, investors may have to provide additional funds to cover expenses. Raw land DPPs. Raw land DPPs are considered the riskiest real estate DPP because the partnership doesn't have any cash flow, no rental or sales income, and the value of the land may not increase. It may actually decrease. In addition, investors cannot claim depreciation deductions because land cannot be depreciated. Blind pool. This type of DPP gives the general partner wide discretion as to the types of investments that the DPP makes. A blind pool DPP may have a stated goal of growth, income, and so on, but the investment choices are left to the general partner. One of the advantages for real estate DPPs that invest in existing properties such as public housing DPPs and existing property DPPs is real estate depreciation, which means you can write off the value of an asset, in this case homes or buildings, over the useful life. I know it sounds strange, but investors can actually write off the value of a house or building. Land is not depreciable over a set number of years, such as 10, 20, 25, and so on. At the end of that period, you're written off enough so that, according to the IRS, your home or building is worth nothing, even though it's most likely appreciated in value, and you can't take the additional depreciation write-offs. Although things like equipment can be depreciated on an accelerated basis, real estate DPPs can only depreciate on a straight line basis, writing off an equal amount each year. The following question tests your understanding of real estate DPPs. Which of the following types of real estate DPPs have the fewest write-offs? A. Raw land. B. New construction. C. Existing properties. D. Public housing. The correct answer is choice A. DPPs can invest in raw land. That invest in raw land are buying property and sitting on it with the hope that it'll be worth more in the future. Because the DPP isn't spending money on improving the property and land can't be depreciated, raw land DPPs have the fewest write-offs. Equipment leasing. Although you could be tested on equipment leasing programs on the Series 7 exam, it's the least tested type of DPP. Equipment leasing programs purchase equipment, trucks, heavy machinery, planes, railroad cars, computers, you name it, and lease it out to other businesses. The objective is to obtain a steady cash flow and depreciation write-offs. The two types of leasing arrangements you need to be aware of are the operating lease and the full payout lease. Operating lease. This type of equipment leasing program purchases equipment and leases it out for a short period of time. The DPP doesn't receive the full value of equipment during this first lease. This type of arrangement allows a DPP to lease out the equipment several times during the life of the machinery. Full payout lease. This type of equipment leasing program purchases the equipment and leases it out for a long period of time. The DPP receives enough income for the first lease to cover the cost of the equipment and financial costs. Usually the initial lease lasts for the useful life of the equipment. The main thing to remember about equipment leasing is that the operating lease is riskier because the equipment becomes less valuable or outdated over time and therefore less runnable. In other words, no appreciation potential. However, equipment leasing programs, unlike real estate programs, may qualify for accelerated depreciation, being able to write off more in the early years and less in the later years. Oil and gas. Oil and gas partnerships include programs that produce income, are speculative in nature, or are a combination of the two. You need to know how the types of programs differ along with their risk and potential rewards. Oil and gas partnerships also have certain tax advantages that are unique. Intangible drilling costs. IDCs are write-offs for drilling expenses. The word intangible is your clue that you're not talking about actual equipment. The costs include wages for employees, fuel, repairs, hauling of equipment, insurance, and so on. IDCs are usually completely deductible in the tax year in which the intangible costs occur. IDC deductions are only for the drilling and preparing of a well for the production of oil and gas. Therefore, when a well is producing, IDC write-offs are not allowed. IDCs provide a tax advantage to exploratory programs. Tangible drilling costs. TDCs are write-offs on items purchased that have salvage value, items that can be resold. All oil and gas DPPs have TDCs, which include costs for repurchasing items such as storage tanks, well equipment, and so on. These costs are not immediately written off but are depreciated over 7 years. Depreciation may be claimed on either a straight line basis, writing off an equal amount each year, or accelerated basis, writing off more in early years and less in later years. IDCs are fully deductible in the current year. TDCs are depreciated over several years. Depletion. Depletion is a tax deduction that allows partnerships that deal with natural resources such as oil and gas to take a deduction for the decreasing supply of the resource. Partnerships can claim depletion deductions only on the amount of natural resources sold, not extracted and put in storage for future sale. Depletion deductions are only for DPPs that deal with natural resources. On the Series 7 exam, the only DPP with depletion deductions that you need to be concerned with is oil and gas. When investing in oil, partnerships can pioneer new territory, drill near existing wells, buy producing wells, or try a combination of these methods. For Series 7 exam purposes, exploratory programs are the riskiest oil and gas and DPPs because oil may never be found, and income programs are the safest oil and gas DPPs. To make your life easier, hopefully, I've composed a DPP comparison for you to listen to help you focus on the main points of each type of oil and gas DPP. Advantages and risk of various oil and gas DPPs. Exploratory wildcatting programs to locate and drill for oil in unproven, undiscovered areas. Advantages: long-term capital depreciation potential, high returns for discovery of new oil and gas reserves. Risk: riskiest oil and gas DPP because new oil reserves may never be found. High IDCs because the DPP isn't working with producing wells. Developmental programs to drill near producing wells, improving areas with the hope of finding new reserves. Advantages: long-term capital appreciation potential, not as much as exploratory programs, with less risk than exploratory programs. Oil will likely be found. The risk: the property is expensive. The drilling costs may be higher than expected. The risk of dry holes, non-producing wells, is still somewhat high. Medium level of IDCs. Income programs to provide immediate income by producing wells. The partnership generates enough cash flow. The least riskiest of oil and gas DPPs, no IDCs. The risk: high initial costs. The well could dry up. Oil prices, gas prices could go down. Combination with balanced programs to provide income to help pay for the cost of finding new oil reserves. The ability to offset the cost of drilling new wells by using income generated by existing wells are the advantages. The risks are that it carries the risk of all the programs combined. The following question tests your knowledge about the concerns with different DPP investments. Ayla K has money invested in a limited partnership that's expected to have a significant amount of income over the next 1 or 2 years. Which one of the following programs would best help Ayla shelter the most of that income? A. Oil and gas exploratory. B. Raw land purchasing. C. Equipment leasing. Or D. Existing real estate property. The answer you want is choice A. Oil and gas exploratory programs spend a lot of money attempting to find and drill for oil. These programs have high IDCs, intangible drilling costs, which are fully tax deductible when the drilling occurs. Therefore, the oil and gas exploratory programs have the largest write-offs in the early years, which could help Ayla offset some or all of her passive income from the other limited partnerships.